for joining Thompson Hine's weekly Coffee Chat series. My name is Cassandra Borchers. I'm a partner in our investment management group. This is our fifth and actually a bonus webinar in our weekly Coffee Chat series, which is normally on Wednesdays. These concise and practical discussions will focus on a variety of developments that impact the financial services industry. Joining me today is Julie Thomas. Julie is the Chief Compliance Officer for Fund Evaluation Group, or FEG as it's well known in Cincinnati. FEG is an independent, employee-owned, full-service advisory firm, and Julie has a compliance background that spans over 15 years. FEG's mission is to empower their clients to achieve their goals through superior investment performance, objective insights, and research. Julie, thank you for sharing your time and expertise with us today.
I'm glad to be here.
Okay. So in today's session, we are going to focus on and discuss the Form ADV annual update, which for most advisory firms, anyone with a calendar year end is due right around the corner at the end of March, and provide some practical tips and guidance. If you have any questions or comments during today's program, please feel free to join the discussion. You can enter the Q&A function and submit a question, and we'll try to address those during the course of the discussion. If not, we'll catch up at the end. So that being said, let's get started. All right, so Julie, the first topic on the agenda, COVID-19 and the 2020 pandemic. The world certainly did change last year with the outbreak of the coronavirus. This could potentially lead to some changes or new responses on Form ADV as a result of the pandemic. We note our experience has been that most advisory firms are at least partially still in business continuity mode. All of their employees may not be coming into the office, and they might be working from home or a remote location. Add to that the payroll protection program, that loan program for PPP loans that may need to be disclosed on Form ADV as well. As a practical matter, what impact do you think these issues will have on the Form ADV for the 2021 update?
Well, I just completely agree with you, first of all, that, about the new world that we are in with the pandemic. And certainly our firm is no different than many others. We are still, we still have a majority of our staff that are working remotely from home offices and throughout Cincinnati. So, and some of our other locations. But, you know, to address that on your Form ADV, the SEC has put out some guidance and FAQs to advisors that are operating under their business continuity plan, and really indicated that they do not have to list those home offices as other satellite offices for the firm at this point. Now, as people do move back into their offices or changes become more permanent, and I believe that may happen for some firms where people are now going to be working from home on a permanent basis, then you would want to consider disclosing those offices on your Form ADV. As far as the PPP loan, again, the SEC has put out guidance that if an advisory firm has taken on a PPP loan, there may very well be an obligation to disclose that on your Form ADV Part 2 under Item 18. I believe they said specifically that if you used that PP loan to pay salaries of employees that are primarily responsible for performing advisory services to your clients, then they believe that it's the SEC's point of view that you should be disclosing that loan. And then I think just in general, you should be thinking about any other disclosures that may be appropriate given the extended period working from home. If you've been successful, you may not have much to disclose on that front, but you should consider if you've had any hiccups or any kind of issues that have arisen from that work environment.
Great. I imagine there's plenty of material for the CCO's annual review of the business continuity plans, coming out of 2020. So you mentioned the FAQs. I did want to point out for everyone, those FAQs can be found in a couple of different places, and the Division of Investment Management actually put out a coronavirus COVID-19 response FAQs where they compiled them with respect to the investment advisor, investment companies, broker-dealers, et cetera. And that information is available on the SEC website. One other good tidbit that came out of that, the staff said they would not view an advisor's reliance on temporary relief during 2020 as a risk factor for examining an advisor's business continuity plan. And also in that one FAQ, it has links to other relevant guidance. So it might be worth checking out. Okay, yeah. So I mean, given that, and I know firms are, anyone with a March deadline is probably in the thick of this. So maybe it's a good idea to take a step back and talk about the purpose of Form ADV, how it's utilized by the regulators, how it's organized. Anything related to what happened in 2020 and the pandemic should also be analyzed through the lens of a regular Form ADV update. So maybe you could talk about that for a few moments.
Right, just to take a step back and really think about the purpose for your Form ADV. It's basically a mechanism that regulator is able to gather information about your firm and to really understand the risks and create a risk profile for your firm. Additionally, it is to your clients, it's an opportunity for you to disclose any conflicts of interest and other important matters about your business activities and the way that your firm operates. So there are a number, it's really just to put information out there about your firm. And for those of you who are newer to this process, we'll just go through some of the different parts of your ADV. So you have part one, which is organized in a check the box or fill in the blank format. And the SEC, as I said, gathers this information and uses it to manage their schedule and their examinations of advisors. So they're kind of looking at your risk profile and using that information for that. And they also are looking at things more broadly, looking across different firms and looking at trends that they're seeing in the industry. Part 2A is also known as the brochure. It's supposed to be written in plain English and provide various disclosures about business practices, fees, conflicts of interest, and disciplinary information, among others. Part 2B is known as the brochure supplement and actually discloses information about specific individuals acting on behalf of the investment advisor. Primarily, these are individuals that are providing investment advice or have direct interactions with the clients. And now, lucky us, we are looking at part 3, which is also known as Form CRS. It was new to the lineup last year. And also it's called the relationship summary. And this is a document that's required for SEC registered investment advisors that are providing investment services to retail investors. So it's another way of taking a concise look at the business operations of your firm and providing it in plain English for retail investors. It's important to note that they are looking at the fees and the costs that are incurred by the clients, what conflicts of interest you may have, the standard of conduct, and then it also provides questions that you should be asking your advisor as well. So that was an interesting twist for those of us who had to deal with it last year.
Sure.
I think most importantly, it is a document that provides a lot of information and to a number of different audiences that should be considered as you're drafting your document.
Great, thank you. So to sum up, I think it really just gives a snapshot of the business of the company, regulatory assets under management, types of clients, conflicts of interest, et cetera. As I'm sure everyone's aware, it's due to be updated basically within 3 months of your fiscal year end. And, You can use the 1231 number for that information or anything more recent, depending on what you'd like to accomplish. We note the Form ADV is also required to be updated annually, but not Form CRS. I think there's some different provisions in there about updating that. Also, it's interesting that I think going back to 2016, there have been some pretty significant changes to Form ADV just about every year. So 2020, we get a little bit of a pause on that, and we'll be jumping in again next year. We'll talk about that in a few minutes. The other question that we frequently get is how to calculate your regulatory assets under management. You have to do those calculations annually, as we just mentioned, and maybe you can talk us through some good tips on how to do that, how to document it, so that you can get it right.
Absolutely. I think what you said within your question really is the most important thing, and that is to keep documentation. Keep those supporting schedules that you use to determine your assets under management. Familiarize yourself with the instructions so that, because I think it's pretty clear, as clear as it's going to get anyway, for determining what assets you count. The regulators do say that regulatory assets under management should include securities portfolios for which you provide continuous and regular supervisory or management services. Now, you would look at, there are times that we need to consider different clients, new client groups, and figure out exactly where they fit in the definition. So we make a determination on how to include them or not. So for the most part, clients where you have discretion would be included, but there are other clients that might also be included where you don't have discretion, but perhaps you're executing the transactions or the trades for those clients after they make the decision that they want to invest. So key is to make sure that you retain your documentation. I will say that when a regulator does come to visit you, and I'm sure they will be there eventually, they will ask to know, to see that documentation and support. I know when they visited our offices last time, they had specific questions around our regulatory assets under management, and we were able to refer back to our calculation and provide them with the schedules that we used to make that determination. I would hate to have to sort of figure out how you calculated a number after the fact if you didn't retain that documentation. Important things to remember, sort of pitfalls, are overstating your assets under management. That has been sort of a finding from the regulators with some of their examinations, and they've put out some risk alerts around that. You also want to make, as I mentioned before, make sure that you have adequate documentation. You don't want to count AUA, assets under advisement, as AUM. And that's real. I think, I would say there are times that you just need to refer back to the instructions for Form ADV to make a determination on how to treat a specific client.
Absolutely. We assist clients, and I know they have to go through that process all the time when they have a new type of client. The other thing, you mentioned assets under advisement, and there is that miscellaneous section on Part 1 that you can include a variety of things. It doesn't need to, well, this would relate to Part 1, but it doesn't necessarily need to relate to Part 1. And sometimes that miscellaneous section is a good place to point out additional information that you would like to provide. So something to consider. The other question, or the other issue we deal with, we have a lot of private fund clients. And so in that context, we deal with umbrella registrations where there may be a relying advisor. We are typically dealing with this in the context of a general partner, of a private fund. But back in August 2016, Form ADV was updated to adopt that umbrella registration construct. You can now add relying advisors to Form ADV. And just for anyone who doesn't know, the definition's right in there, but a relying advisor is an advisor that is controlled by or under common control with the filing advisor, assuming they conduct their advisory business as a single entity. There's plenty of guidance out there on what is not a relying advisor. And if you have a question and you need to work through those issues, I think it's just important to go look at the instructions and look at the guidance. Along with that, there is that new Schedule R, and you will complete a Schedule R for every relying advisor that you do list on the form. And then on the firm brochure, you would list not only the registered advisor, but also the relying advisors as well. So you also mentioned previously, Julie, I think you were talking about an examination and scrutiny from the SEC. Maybe you have some things in mind that you think would draw closer scrutiny from the SEC that people should be cautious about, maybe particularly careful in documenting when they're preparing their annual update?
Yes. I definitely, well, I have heard regulators in many industry conferences state that they are, they do a risk profile on investment managers, investment advisors in their offices. They may bring up your firm and pull up the ADV and pull up your website, and they do use that to kind of address risks or look at the risks that are identified with your firm. And so I do believe that they look at that documentation. They may not be physically on site. They may not do a formal examination, but they are considering the information that you're giving them year over year. So things that I think pop out for a regulator, and this is all of my own speculation, but something that might raise a red flag or raise your risk profile would be a big change in your AUM. So and that could be a big increase or a big decrease. Adding new funds, adding new private funds might also raise your risk profile. Certainly failing to file your ADV in a timely manner would raise your risk profile because they may be questioning what's going on with your compliance program. Inconsistency year over year on how your questions are answered under Part 1. One year you're checking yes, the next year no, and back to yes again. Or custody issues where you're claiming custody, then you're not claiming custody, and back and forth. So consistency is important. Consistency from year over year, but also consistency throughout your Form ADV. So you don't want Part 1 to say one thing and Part 2 to be completely disconnected from that. Other things that might raise your risk profile are changes to your organization's structure. Changing from a partnership to an LLC or employee-owned entity, like we changed to recently. Significant changes in your leadership or officers could also raise a flag. You don't want to see someone cycling through CCOs every other year. I think that would certainly raise some eyebrows at the SEC. And then significant changes to your employee count, unexpected changes. Perhaps you have a large decrease in your employee count, and yet your products and services remain unchanged. So that may raise some scrutiny. Custody is a favorite topic of the SEC and an area that they're particularly interested in. So if you would have a significant increase in your assets that are deemed to be custodied by you, that may also raise a risk profile. Conflicts of interest are another area, and that could be any number of things that they're looking for, whether it's performance fees, compensation arrangements, related parties, and other topics or other conflicts like that. And then lastly, if they're looking at your ADV and they happen to pull up your website, any inconsistency that they see with what you're putting out there to clients and potential clients versus what you put in your ADV would also raise concerns from a regulator.
Yeah, you raised the website. I know it takes, it takes a village. And in the context of preparing the Form ADV, making sure the website's consistent, all of the things that you just mentioned, obviously you as the CCO are the one actually filing the Form ADV, but I imagine you need to get input from several different people within the organization. Everyone has their piece to play. And I know many firms have like a policy and procedure as to how they go about updating Form ADV. Maybe it's in writing, maybe it's not, but certainly that's a best practice that we recommend because it's, it's easy to get tripped up on some of these items.
Yes. My advice to everyone is to start as early as you can with the process. And, involve other, for us, from our firm, we have other people on the compliance team that are very active in getting our ADVs filed. They're doing a lot of the legwork right now, gathering information from different areas around the firm. We compile all of that data, but we certainly are not the only ones that are responsible for it. So we work with people across the firm, across the business to gather the information that ultimately goes into the ADV. We have developed consistent procedures. We don't have a formal play-by-play on those, but we do have documents and files where we store all of those documents and sort of lay out the ground, the process, and we follow that same process year over year. It's helpful for consistency, but it also, for the next preparer, shows them how we arrived at a particular number that might be shown on our ADV. And we keep all of the supporting documentation in those files and all the supporting schedules. It also preserves the final draft, any changes, and it just makes it much easier to do those updates on a going forward basis.
That triggered something else I had meant to mention earlier. With respect to the PPP loans, our advice has been I think in most circumstances, the advisors need to disclose, or maybe they have already disclosed the fact that they took a PPP loan last year. And if you go through the analysis and you come to the conclusion that you do not need to disclose that information, the staff has said, and certainly in any case, you would want to write a memo, document that for the file, put in your precise analysis, because my expectation is, that the staff would ask about that if it were not disclosed. So certainly any items like that or anything that falls outside the normal course, be cautious. And last year,
great point. If you determine that you don't need to disclose something, keep that documentation as well, because you may be challenged and you want to be able to have that available to you immediately if a question is raised, and refer back to it to go through the process that you use to determine that disclosure or not.
Right. And tying back again to 2020, I'm sure everyone saw that the temporary relief as the pandemic was just hitting and the world was closing down in March. The staff did give some temporary relief in 2020 for advisors who felt like they could not get their Form ADV updated in a timely fashion, before June 30th, depending on when their deadline was. I'll just note no similar guidance has been given this year, and we wouldn't expect it given the fact that we've been living with this now for quite a while. So Form ADVs need to be filed timely again.
Yes.
Okay, well, we're getting close to the end, but before we go, could you talk about, you've done this a little bit, but I think maybe you've already covered all of it, but just thinking through best practices and whether and how those have evolved over the years.
Well, as I said, to me, best practice is just to start early and involve other members of your team. You don't want to take it all on. We have 4 ADVs that we have to file, 4 separate documents, and really considering each advisor that we're filing in their business and making sure that we understand any changes or developments that have happened throughout the year that maybe we are not aware of, but maybe revisiting with our legal team to make sure that we understand any new contracts that we've entered into that may need special disclosure on the ADV, any particular terms that have been offered to a client that we have not been involved with up until now, to understand that as well. So start early, document, and retain all of your supporting schedules for your next examination. Sorry, no one probably wants to hear that, but that's
right, but that's the reality. And then, the SEC just passed their modernization of the marketing rule. That's expected to become effective this year. So what are we seeing there with respect to additional disclosures that are anticipated on Form ADV?
Yes, that new regulation will have some increased disclosure that will be required on Form ADV Part 1. They are expanding item 5. There will be a new subsection under that item. It'll be subsection L. That's called marketing activities. And it's basically a number of yes and no questions that are being asked around the marketing activities that your firm utilizes, and that would include, they will be asking about whether or not your advertisements include performance results, specific investment advice, testimonials, endorsements, third-party ratings, hypothetical performance, and predecessor performance. So again, I think all of that information will be viewed and reviewed by the SEC and used to develop a risk profile for your firm and to just understand what's going on out there. So take note, these questions are coming. Fortunately, they're not on there this year. You don't have to worry about it for a while. Most advisors will not have that disclosure until March of 2023. So just given the expected effective date and then the actual compliance dates that are anticipated, it's likely that you will not have that enhanced Form ADV until 2023. So we've got a little breathing room. You might want to familiarize yourself with the requirements in the next couple of years.
Right. Just add that to the to-do list. Well, we're just about out of time. Are there any questions? I'm not seeing any in the Q&A or chat function.
I didn't see any either.
All right. Well, then we'll give everyone a few moments of their time back. This concludes the chat today. If you have any other comments or questions, please feel free to reach out to me or to Julie. I'll offer her up as well. The next Coffee Chat series will be hosted next Wednesday, which is March the 3rd. And we are actually doing a 3 presentations around the new advisor advertising rule. We'll highlight all of the key changes that are going to come into place with practical considerations for compliance. Next week, the first of those is the SEC's new marketing rule, redefining advertisement. To register for future Coffee Chat discussions, visit the events page on the Thompson Hine website. And thank you all for attending today and your interest in the program. When the webinar ends, you will be prompted to take a survey to provide us a little bit of feedback. We use this so that we can continue to tailor programs to your needs. Thank you again and enjoy the rest of your day. Julie, I can't thank you enough.
Oh, thank you. Happy ADV season, everyone.
Yeah. Good luck on those 4 ADVs.
Yes.
All right. Thank you.